Wills and administration of estates in Nigeria. This video explains in clear and practical way how estates are administered after death under the Nigerian law. It goes ahead to explain the difference between testate and intestate succession, how wills operate, and what happens when a person dies without a valid will. It also looks at the role of executors and administrators, probate and laters of administration in simple language. At the end of this video, viewers will understand 1. The meaning and importance of a will. 2. What intestacy means under Nigerian law. 3. When a will can fail or become invalid. 4. The purpose of letters of administration. 5. The different types of letters of administration. 6. The duties and powers of executors and administrators. 7. How estates are distributed after death. 8. Why probate is important. 9. Legal consequences of intermeddling with a deceased person's estate. 10. The rights and responsibilities of personal representatives. 11. How debts, taxes, and assets of a deceased person are handled. 12. The difference between executors and administrators. 13. What happens when there is partial intestacy. 14. The role of the probate division of the High Court. 15. Basic principles of succession and inheritance law in Nigeria. Now, who is this video for? This video is especially for law students, Nigerian law school students, lawyers and legal practitioners, family dealing with inheritance matters, anyone interested in wills, probates, and estate administration, people planning their estates or preparing wills, and students preparing for law examinations. This video will make the viewer have a strong foundational understanding of Nigerian succession law and estate administration. Let's get started. The law relating to administration of estates is born out of the reality of nature that everyone must die at one time or the other. And most persons die leaving property behind. The purpose of the law relating to administration of estates is to ensure that such property does not become a problem not only for the surviving relatives of the deceased, but the society generally. The problems that could arise include issues as to who is entitled to inherit the properties of the deceased. In what proportion should the beneficiaries inherit the properties? How to identify and put together the properties of the deceased as at the date of his death, and which law governs the personal life of the deceased. The procedure for legally inheriting and vesting the properties in beneficiaries, and payment of the debts owed by the deceased in his lifetime. Accordingly, the properties of every deceased person are subject to administration and distribution under the law. This is achieved through A. Disposition in the will of the deceased person where he has made one. B. Customary law. Under the particular customary law to which the deceased was subject in his lifetime, if he has died without leaving a will, that is, he died intestate. C. Common law. Under the common law rules on intestacy as applicable under the reception statutes where the deceased was domiciled or originated from. A state without a localized administration of estate statute. If he has died without leaving a will, and he died not being subject to customary law, and D. Administration of estate law applicable in the particular state of the federation. The above explanations patently represent the sources of the applicable law on succession in the properties of deceased persons in Nigeria. Now, what is a will? A will is a document made by a person who is referred to as a testator, by which he appoints persons known as executors to manage his estate after his death, and directing the manner in which the estate is to be distributed to named beneficiaries. A will has been described as a testamentary, ambulatory, and irrevocable document voluntarily made, executed, and witnessed according to law by a testator with sound disposing mind, wherein he disposes of his property subject to any limitations imposed by law, and wherein he gives such other directives as he may deem fit to his personal representatives, otherwise known as executors, who administers his estate in accordance with the wishes maintained in his will. A person who died leaving a will behind is said to have died testate. A person who makes a will is called the testator, while the person that is named in the will to implement it is called an executor if it's a male, or an executrix if it's a female. Now, the term intestacy. Many persons die without making wills, notwithstanding the advantages of wills. In such a case, a person who died without leaving a will is said to have died intestate. Even if the person dies after writing a proposed will, but the will fails or is declared invalid for any reason, such a person is deemed to have died intestate. That is, he or she had died without a will. One of the direct results of a person dying intestate is that his properties may be exposed to squander, and sometimes beyond reach, especially when there are no known persons entitled to inherit the estate. In some cases, the estate is taken over by the Administrator General on behalf of the state, since such estate may be treated as an unrepresented estate. Now, we have what is called letters of administration. In order to avoid the squandering of the estate of a deceased person who has died without leaving a valid will behind, there is a need for his personal representatives to procure letters of administration for the purpose of legally and properly administering the estate. A letter of administration is a document issued from a court of competent jurisdiction, that is, a court with requisite jurisdiction authorizing specified persons known as administrators to manage the estate of an intestate person. It is the alternative to a will where there is no will, or there has been a failure of a purported will for some reasons. Why is a letter of administration required? The need for letters of administration arises when a person, one, dies leaving a will but fails to name an executor in the will, or name an executor who is unable or refuses to obtain probate. That is a certificate issued from the probate division of the High Court to the executors of a will, certifying that the will is valid and that the executors are authorized to administer the estate. Or, for any reason, the named executor predeceases, that is, died before the person who made the will. In this kind of situation, the will is annexed to the application for letters of administration, which is then known as letters of administration cum testamento annexo. That is, letters of administration with the will annexed to it. 2, dies without making a will at all, or 3, leaves a will but nonetheless dies intestate as to some beneficial interest in his real or personal estate. In other words, some of his properties are not covered by his will, and he is intestate in respect of them. That is partial intestacy. Letters of administration necessitated by any of the above situations are issued by the probate division of the High Court pursuant to the provisions of the administration of estates law of the estate where such laws exist, and their High Court rules. And where the deceased was not subject to customary law as at the date of his death. Letters of administration confer legal administration on the persons specified therein, not only to have access to the properties of a deceased person, including funds and other choices in action, but also to deal with same as every personal representative of a deceased person would. In other words, letters of administration legally confers on the person specified therein the powers, functions, and duties of personal representatives. Funds and other assets belonging to the deceased person in his lifetime, but which are in the custody of banks, insurance companies, and the benefits of company and cooperative societies, shares held in the name of the deceased estate person cannot be fully accessed by his family or any person otherwise interested therein without the production of a valid letter of administration. Types of letters of administration. From the above, 2 types of letters of administration are available to the estates of a deceased person. These are A, letters without a will, and B, letters with will annexed. The two are provided for in the administration of estate laws of the states of the Federation, with such laws and, where applicable, the common law rules on intestacy. See, there is also a third type of letters of administration which may be described as customary letters of administration. These are issued from customary courts with requisite jurisdiction thereon. For example, in Delta, Edo, and Edo states of Nigeria, this type is actually a subtype of type A above, dealing with letters without a will. What differentiates this type of letters of administration is that they are issued by customary courts, as opposed to letters of administration without a will issued from the probate division of the High Court. Other types of letters of administration include letters ancoligenda bona, which is like an interim order authorizing any person to deal with specified property being part of an estate pending a full and permanent grant of representation. And letters of administration ad colligenda bona is resorted to when the property to be dealt with is, for instance, in perishable state, or when delay in dealing with it may expose the estate to loss. It may be granted to any suitable person who may not necessarily be a person entitled thereto. Letters of administration durante absentia is one granted to an appropriate person in the absence of an executor who is abroad or who is overseas. And 3, letters of administration de bonis non administratis, which is one made to some new person where the person to whom a previous letters of administration was granted dies before completing the disposition of the estate. When a grant is made by virtue of the issuance of letters of administration, the person to whom the administration is granted are known as administrators or administratives if she's a woman. Administrators, therefore, are persons appointed by the court to administer the estate of a deceased person by gathering and distributing the properties or assets and liabilities of the deceased person who has died intestate, that is, without leaving a will behind, or died leaving an invalid will, or will without appointing executors, or where the executors appointed in the will cannot act or have refused to act. Now, who are executor and executrix? An executor male and executrix female is a person appointed in a will by a testator to administer the estate of the testator upon his death in accordance with the instructions contained in the will. An executor or an executrix is like an administrator, the personal representative of a deceased person. But while an administrator or administratrix is usually appointed by a court, the executor or executrix is appointed by the testator in his lifetime, in his will. Generally, the position of the law is that upon the death of a person and prior to the grant of probate or letters, death devolves upon the beneficiaries of his estate the equitable interest thereof. When the deceased has left a will, the legal interest will vest in his executors. But when he has died intestate, the legal interest in respect of his estate will, upon grant of letters, vest in his administrators. In effect, an administrator does for an intestate estate what an executor does for a tested estate under a will. Both are generally referred to or generically referred to as personal representatives. If the testator creates a trust under his will, the personal representatives will be under a legal duty to vest the trust property in the trustee. This is achieved by way of a vested assent by deed, which in effect transfers the legal interest in the trust properties to the trustee. Where the personal representatives are also the trustees, under the will, the vesting of legal interest is implied. Personal representatives exercise certain powers in respect of the estates they represent and are also subject to certain duties, obligations, and rights. Now, duties and rights of personal representatives. Personal representatives derive their powers to legally administer the estate of a deceased person only upon the grant of valid letters of administration or probate to them. Probate is a legal recognition of the validity of a will and the title of the executor to the estate of the testator. It is also known as the official proving of the will. It is granted by the probate division of the High Court. Any person may oppose the grant of probate or letters of administration to the personal representative by filing a caveat, which is a notice in writing to the register not to make a grant to the applicant or applicants for probate or letters of administration without giving the caveator, the person opposing the grant, a right to be heard in opposition. Without such grant, every act done in connection with the estate amounts to an intermeddling, and such persons meddling, even when it is their customary law right to do so, cannot sue or be sued in respect of the estate. In the same vein, a person will be without locus standi to defend an action if sued as administrator or executor of an estate of a deceased person when such a defendant is not ascertained to have been appointed an administrator or executor by letters or probate, as the case may be. Such a person is an executor disjunctor, and an executor that is an executor by his own wrong. Upon the appointment following a grant of letters of administration or probate, certain legal duties are attached to the personal representatives. These include a gathering and realization of assets, the first duty of a personal representative. Whether he's an administrator or an executor, is to identify and define the estate by collecting together all the assets and liabilities of the estate. In other words, It takes an inventory of all the properties and assets in the estate, as well as its debts and liabilities. A personal representative derives his powers to administer the estate only upon the grant of probate or letters of administration. B. Application to court. The personal representatives have a duty to apply to court for an order of court granting them powers to administer the estate of the deceased. This is important to give validity to all their acts respecting the estate since the death of the deceased. This is more so as without a grant, they may not be able to administer certain types of assets. For example, bank credit balances in favor of the estate. 2. Proceeds of insurance policies. 3. Company shares. 4. Interest in cooperative society and such likes assets which cannot be accessed without formal authorization as by probate or letters. C. Payment of debts and liabilities. Where the deceased was owing any debts as at the date of his death, the administrators of the estate are under a duty to pay such debts. The debts could arise from loans obtained by deceased person while alive and which remained unpaid as at the date of his death. Rents, sundry bills, for example, electricity bills, bank overdrafts, taxes outstanding, interest due on loan, and so on. D. Payment of estate tax. Every estate of a deceased person is subject to a tax known as estate tax upon a grant of probate or letters. The estate tax is a form of indirect tax which is imposed on the value of the property comprising the estate of a deceased person following the grant to his personal representative of powers to administer the estate. It is the duty of the personal representative to pay this tax. Accounts and records. The personal representative of an estate must keep clean and proper accounts and records of their administration. They are also entitled to reimbursement for all necessary and reasonable expenses incurred by them in the course of their administration of such an estate. F. Not to profit. Personal representatives are under a general duty not to profit from the administration of the estate, but will be entitled to reimbursement for all personal funds expended on the estate for purposes thereof. G. Right of action. An administrator has the right to sue in relation to the estate that he administers and a duty to defend all suits on behalf of the deceased estate. In this respect thereof, only actions in rem are sustainable by or against the estate as a cause of action in personam, or a personal right of action dies with the person. Action personalis morito cum persona. Distribution of estate. The final duty of personal representatives with respect to the estate is the distribution of the remainder of the assets to persons entitled thereto, that is, the beneficiaries of the estate. If you enjoyed this video, please subscribe, like and share to encourage this channel.